So, all right. So a couple of things. So first of all, I am recording these. I was having trouble getting them uploaded to Twin, but it turns out that I have to post them to YouTube. So then I posted a link to my YouTube account from when I was in college. So yeah. But there are links posted to the ones that we've done so far. And then I obviously will post them usually by the next day. It just takes a while to convert. So just so you guys know that. But I've gotten it to work and now I feel like I know it pretty well. So it's not bad. So we'll go ahead and get started. What I've done tonight, because this is new where I'm not like actually, obviously this session, they're live stream only, for the last couple. So what I thought I would do is annotate them. Can you guys all see my screen? I'm assuming yes. Let's see. Okay, cool. So I annotated the questions so that you guys can see sort of my notes on them, and I'm highlighting the keywords that I thought were the words that the fact patterns kind of turned on, that identified the issues. So so I'm going to go through that so you guys can see my screen. I'm highlighting the keywords, and I did annotate some of the answer options too. Just that kind of highlights the things that like I see when I go through them. All right, so let's get started. So we're going to start with torts MBEs. These are, so I have them pulled up. They are posted to the Twin page, and there are copies of everything that are posted to the, I think there are sets of like close to 100 MBEs from Barbary posted to Twin. And then also I think that there are some hard copies. I don't know if it's a sets of 100, but there are some hard copies of the questions as well on the 13th floor. So you can feel free to grab some of those. All right, so that being said, let's start with question one. So question one, so generally speaking, when we have an MBE, we're going to start reading the call of the question just because we want to see if it identifies what the issue is. Oftentimes with torts, like 70% of the MBE questions with torts will not identify the call of the question for you. So a big part of the challenge with torts, and a lot of people sort of are surprised with torts. They're like, I feel so comfortable with torts. Why am I not doing better? Why is my performance not better? And part of the reason is because the torts questions are just tricky. They're tricky and they're not identifying what's at issue. So, if they were to tell you that it's assault or battery or negligence or NIED, then it would be, make it a heck of a lot easier, but that is part of the challenge. So that is part of your responsibility is identifying that. All right. And so did you guys all look at these first 10 questions? I'm assuming yes. And you guys can have your mics on and you can just tell me yes. Okay. Or you can type yes or Y or whatever it is. All right, cool. So on this first one, so we have in a suit by the prosecutor against the ex-convict for defamation, what would be the probable result? So this is good. So this tells us that defamation is at issue. So then we would want to write at the top of the problem, we'd want to list out the rule for defamation or the elements. And remember that for defamation, you have to have the different, there's the different standards for the type of defendant. So that's something that you've got to think about. So we want to see here, what type of defendant. Is it a private person? Is it a public person? So then what's the standard? So here we have an ex-convict who spent 9 years in prison for car theft, vowed to get even with the prosecutor of his trial. So we have a bad guy. Oftentimes, the bad guy is going to win. I don't know if that's going to happen in this case, or I don't recall just off the top of my head. But oftentimes the bad guy is going to win. Don't make assumptions. So, just because you don't like someone, don't make an assumption based on that. So while in prison, the ex-convict was told by another prisoner, a drug dealer, cool, that when the prosecutor was in private practice as a criminal defense attorney, he had represented the drug dealer in a drug charge. Okay, so the reason I say cool is like a drug dealer. So you're obviously like the drug dealer is going to be an not necessarily an informant, but they're going to, people talk, right? So you have this guy. It doesn't seem to me to be too reliable of a person, but still. So you might have some doubts as to whether or not, the ex-convict should believe this drug dealer. So, but you remember, you always have to pay attention to state of mind words, and you kind of need to tend to reserve judgment unless you're given a reason to judge or to draw an inference. All right. The drug dealer had claimed that because he did not have the cash to pay the prosecutor his fees, He offered to pay his fees with 5 ounces of cocaine, and the prosecutor accepted. All right, it sounds like an episode of The Good Wife. So, all right, so that's what's going on. And we know we have defamation, so you know that this is probably the information that's going to come out about the prosecutor. And we still don't have any information about what type of defendant it is. So we're still looking for that to identify what's the standard. So just if it's just a prosecutor, then I think, okay, it's probably just a private person, but let's just check. So although the ex-convict had no independent reason to know whether what the drug dealer said was true, he believed that it was. So that right there, the believed that it was, tells us that that's a state of mind word, and you always want to pay attention to that. So when he got out of prison, he learned that the prosecutor is running for district attorney. So now we know that now we do have information about the type of standard, because when someone is running for public office, they become a public figure. This is, on this particular point, a lot of people I know for this question struggle, because they're like, just because you're running for DA, that doesn't make you like a public figure like you are for like the president, right? But in bar world and in this world, like, you know, if you're running for public office, you become a public figure. So here he's a public figure, so the actual malice standard applies. Right, hang on one second. Let me just double check one thing. I'm going to make sure that I'm not misstating that. Yeah, okay. Yeah. So it's the actual malice standard. So he's considered a public figure. There. So the ex-convict went to one of the local papers and sold them the story for $1,000. In the article, so as soon as I see that it's in a paper, I always think, you know, you're trying to say, okay, well, is it libel or slander? Because then you have to think about damages. I always remember, like, for those of you that have had me in class, I like to do word associations to remember which is which. So like, to me, the S's go together. So like, slander is spoken. So then I know libel is written. So here, the ex-convict went to one of the local papers and sold them the story for $1,000. In the article that resulted, the ex-convict was quoted as saying, "I only hope that the prosecutor suffers like I had to suffer for the last 9 years." Although the allegation was false, the prosecutor withdrew from the race as a result of the article. So there is some damage there. Or there's an injury there because he had to withdraw from the race. It was a false allegation, so you can't have truth as a defense. So there's defamation here. So then there has to be actual malice, right? So then what's the rule for actual malice? So it's knew or had reason to know that it should be false, or that it was false. So here, the ex-convict did not know that it was false, because it says here that he believed that the statement was true. And it also says that he had no independent reason to know whether what the drug dealer said was true. So this tells us that he didn't have actual malice towards the prosecutor. And you have to reconcile, like, that legal standard, the actual malice standard. The ex-convict actually was, like, malicious towards the prosecutor. He really hated him, but he did not act with actual malice in the way that it means for to meet the definition for defamation. Does that make sense to everybody? Okay, good. Good. So let's go through the answer options. So A, the prosecutor prevails because the ex-convict acted with deliberate malice toward the prosecutor. That just straight misstates the law. That's a misstatement of the standard. B, the prosecutor prevails that the ex-convict should have known that the story was false. Again, this misstates the standard. It misstates the standard because, you know, it's knew or should have known. And it also here kind of contradicts, it misstates the standard. C, the ex-convict prevails because the story was a matter of public concern. It doesn't matter. Here you have to show that there was the actual malice standard was met, and it wasn't. So this is sort of irrelevant. And then D, the ex-convict prevails because he honestly believed the truth of the assertion made by the drug dealer. And this goes exactly to what's at issue, which is, you know, what was there actual malice? And there cannot be actual malice if you did not, if you had no reason to know, and you did not know that the statement was false. Any questions about that one? Okay. Did I say any statements? Any questions about that one? All right. I'm going to move on to question 2. Okay. An ordinance of a city makes it unlawful to park a motor vehicle on a city street within 10 feet of a fire hydrant. So I know I'm in torts, I should start with reading the call to question. So here, if the elderly neighbor asserts a claim against the man, will the elderly neighbor recover? So the call here doesn't give us any information with respect to what the claim is. It just says asserts a claim. So we're going to be trying to figure that out as we go. So be on the lookout for that. So an ordinance of a city, and as soon as I see ordinance, I'm going to think negligence per se. So an ordinance of a city makes it unlawful to park a motor vehicle on a city street within 10 feet of a fire hydrant at 1:55 p.m. So because I see that, I'm like, okay, well, I want to see, is this negligence per se? So is there a violation of the ordinance? Did the plaintiff suffer the type of harm? And if it would fall within the class of persons they were trying to protect. So here, I immediately, when I see what the ordinance is, I want to think about that. So, park a motor vehicle on a city street within 10 feet of a fire hydrant. So, who is that intending to protect? Or what's the purpose of the ordinance? Yeah, exactly. Yeah, it's to have space for firefighters. To have space for firefighters to park fire trucks, right? Yeah, it's public safety. So it's really the public at large that they're concerned about. So it's really the public at large that they're concerned about. So who's the class of persons that they're, so it's really, the type of harm is not being able to get a fire truck in. And the class of persons is really like kind of the public at large that could be harmed if a fire truck couldn't park near the fire hydrant. So that's what we're looking for. And we know here we have an elderly neighbor asserting a claim against the man. So something sounds a little bit fishy already, but let's see what happens. So at 1:55 p.m., a man, realizing he must be in the bank before it closed at 2 p.m. and finding no other space available, parked his automobile in front of a fire hydrant on a city street. So he parks his car. So he's violating the ordinance. So there's an ordinance violation. But this already doesn't sound like, unless a fire truck comes up, then the neighbor's not going to be at issue. So the man then hurried into the bank, leaving his elderly neighbor as a passenger in the rear seat of the car. So here now we finally have the neighbor in the car. About 5 minutes later, and while the man was still in the bank, a woman was driving down the street. The woman swerved to avoid what she mistakenly thought was a hole in the street and sideswiped the man's car. So there's nothing to do with the fire truck yet. So it doesn't look like this ordinance applies. So you cannot use the ordinance for duty and breach. And remember, so negligence per se is another way to establish duty and breach. A couple of things to think about. So you use negligence per se to establish duty and breach. If you're in an essay, so I know we're in abuse right now, but if you're in an essay, you still establish duty and breach, and then you do negligence per se afterwards. Unless you're in a scenario where you have like 3 different negligence claims, and negligence per se applies to one of the defendants. Then you'd probably just replace duty and breach with negligence per se, and then do the rest of the regular negligence analysis. But we'll get to that a little bit later when we talk about essays. Okay. So the woman swerved to avoid what she mistakenly thought was a hole in the street and sideswiped the man's car. The man's car was turned over on top of the hydrant, so she hit him pretty hard, breaking the hydrant and causing a small flood of water. So this isn't, this does have some impact on the fire hydrant, but this isn't what the ordinance is there to protect. The man's car was severely damaged and the elderly neighbor was badly injured. So if the elderly neighbor asserts a claim against the man, will the elderly neighbor recover? So let's look at these answer options. So A, yes, because the man's action was negligence per se. So this doesn't meet the negligence per se elements because this is not the type of the elderly neighbor is not the type of person that the statute was designed to protect, and didn't suffer the type of harm that they were trying to prevent, even though there was a violation of the statute. So A is out. B, yes, because the man's action was a continuing wrong that contributed to the elderly neighbor's injuries. So this actually understates the rules. So what this is saying is that the man's action was a continuing wrong. So this is another way of saying causation, and this is a really weird way of saying it. So it understates the rule. And all this is saying is the elderly neighbor will recover. If B is correct, it's saying that the elderly neighbor will recover from the man just because the man was a cause of the injury. But that's not true. You have to show all the other elements are satisfied too. So that's why I wrote that it understates the rule. Because with B, that's literally just saying yes because the man contributed to the injuries, and that's not true. That doesn't apply. C, no, because a reasonably prudent person could not foresee injury to the elderly neighbor as a result of the man's action. So this is, the one thing here is, duty and breach. You have negligence per se doesn't apply. So then I'm looking for a reasonably prudent person, and you have to establish that. So I'm like, okay, well, would a reasonably prudent person see that, foresee this type of injury as a result of just leaving a car parked like this? And it's, not necessarily, I think on an essay you can make an argument, but here, this one, I'm like, all right, well, I'm not quite comfortable enough to cross it out yet. So I want to just look at D because A and B look bad, but C is like I'm iffy on, and this is where multiple choice I think becomes a bit harder because the correct answer won't always be a good answer. So let's look at D. So D, no, because a violation of a city ordinance does not give rise to a civil cause of action, and that's just a misstatement of law. So A, B, and D are out. So C is the only possible answer. So here they're just saying no, and they're saying a reasonably prudent person could not foresee injury to the elderly neighbor as a result of this type of parking. So C is the correct answer. Does everybody kind of understand how we got there? And I like this question just because it shows an example of like, well, this, like, to me, this is still like C isn't a great response. I would like to see something that's a bit more definitive and that I agree with a bit more, but you're not always going to have that. Any questions about number 2? Okay, good. Thank you. All right, let's look at number 3. So start with the call. So if the salesman sues the hotel for his injuries and does not prevail, what is the likely reason? So here I said rephrase the question. So you can take this one. What we're going to say is, why will the salesman lose? You can just flip that around. So why will the salesman lose? So you're looking for just one definitive statement that gives a reason of why he would lose. So you have here a salesman was staying at a hotel for a convention. Hotels in the area near the convention, a series of robberies. So I'm like, okay, well, it's a series of robberies, so the robberies are foreseeable, where the robber would break into the locked hotel room and then rob the victim by threatening the victim with a gun. All right. So now hotels know what to look for. And even though it's a crime that's being done by a third person, there's the exception, that it's foreseeable if they're on notice of it or if there's a pattern. So in response, the hotel where the salesman was staying had recently re-inspected its rooms to ensure that its hotel room locks were secure and in compliance with state requirements. So the hotel has done something. They've gone in, they've checked its locks, so they're trying to protect the hotel patrons. So the question really is that enough? Like, that, in my mind, is that enough? Or is the hotel now acting reasonably because they did that? Nevertheless, one night during the convention, the robber broke into the salesman's room in the same manner as his other robberies. So it looks like it wasn't enough. But, was it reasonable? Instead of threatening to shoot, however, the robber hit the salesman over the head with a blackjack. I don't even know what that is. I'm guessing it's a weapon, seriously injuring him. If the salesman sues the hotel for his injuries and does not prevail, what is the likely reason? So here we're saying, okay, well, what is a reason why the salesman will lose? And so, the fact that jumped out to me here is that the fact that the hotel had done something. So if they have done something, have they acted reasonably to say, okay, well, they did what a reasonably prudent business would have done. So did they do what a reasonably prudent hotel of like size and experience? Did they do what the other hotels would have done? So if they had, then the man would lose. So I'm looking for something duty or breach related. There's no breach of a duty. So I look at A, and A looks pretty good. So the hotel's management reasonably believed that the hotel room locks were adequate. So if that's the case, then there was no breach of a duty because they acted reasonably. So A looks good, so we're going to keep that. B, the hotel is not vicariously liable for the intentional torts of unrelated third parties. We all know that there's an exception to that. It's when the intentional acts are foreseeable, and that's exactly what's happening here. C, the use of force by the robber was unforeseeable and therefore a superseding intervening cause. That doesn't matter. That's just a completely irrelevant fact. It doesn't matter. It's the fact of breaking in that's actually important here. So C is out. And then D, the hotel was in compliance with the state statute setting minimum standards for hotel room locks. So that's a red herring. This just goes back probably to what you recall in torts, where, an entire industry can be negligent. So just because there's a statute that set a minimum standard, a hotel might have a duty, if that standard is too low, then you might have a duty to do something better. So you might have a duty to act higher than what the statute might require. So A is the correct answer here. Any questions about that? All right, cool. All right. So question 4, I like this. I mean, this one's kind of a weird one, but this one tries to get you in a couple of different traps. So, all right. So if the husband sues a detective for invasion of privacy, what is the likely result? So they tell us our claim, it's invasion of privacy. So you'd want to list out your elements of invasion of privacy. So you have a husband and wife are going through a nasty divorce. The wife hired a private detective. So as soon as I see private detective, I'm like, all right, he's going to spy. So you want to predict what's going to happen. So as soon as I see that, I'm like, all right, the private detective's going to spy. And that's what he does. So hired a private detective to spy on her husband. Yep, there we are. The detective followed the husband to a hotel where he saw the husband meet a woman and go into her hotel room. So I highlight her hotel room because that is, just because it's her hotel room, he also expects it to be a private area for him as well, and that nobody else is going to be listening. So the trip here, or the thing that people get tripped up on is, being able to assert the claim, because some people think, oh, okay, well, crim pro doesn't have a reasonable expectation of privacy. But that's for a government search. And then, to assert a violation of the Fourth Amendment. But here you can have a private tort claim for invasion of privacy, even if you don't have possession of the room, or you're not, the owner of the room at that time, because it was her hotel room. So don't let that get you tripped up. You're in torts here. The detective checked into the adjoining room, placed an electronic listening device on the wall, and listened to and recorded the activities of the husband and the woman in the next room. He did nothing with the information he gathered, however, because the wife's retainer check the detective bounced. It doesn't matter that he didn't do anything with it. He didn't have to publish it. All he had to do was do what he did, which was invade the privacy because he listened to it. Both adultery and electronic eavesdropping are crimes under state law. That doesn't really matter. It doesn't matter if adultery is a crime. It still makes it an invasion of privacy to listen in. And electronic eavesdropping, that doesn't mean that the husband can still sue. So even though it can be prosecuted criminally, it doesn't mean that there can't also be a civil case. So if the husband sues the detective for invasion of privacy, what's the likely result? And so I think that the husband's going to win, but let's go through all the answers. So the husband will win because he had an expectation of privacy in the woman's hotel room. And that is, that's true. He did have an expectation of privacy in the woman's hotel room. B, the husband will win because the detective's eavesdropping was illegal. Doesn't make it illegal at all. Or it doesn't make it, that is not the reason that the husband will win. Even though it is illegal, that doesn't matter. There might be it might not amount to invasion of privacy. And if it didn't, then that wouldn't be a basis for the husband to win. So the husband won because he had an expectation of privacy, and then it meets the definition of invasion of privacy. So C, the husband will lose because adultery is illegal. It doesn't matter at all if what he was engaging in is illegal. So like drug dealers can literally assert I think they could probably have some conversation. They could be in a room and they could assert invasion of privacy if some other person was listening in. Even if you're engaging in a criminal act, it doesn't mean that somebody else didn't commit a tort against you by listening in on it. So D, the husband will lose because the detective published nothing about the husband's activities. It's not part of the elements that it has to be published. So that is question 4. So A is the correct answer. Any questions about that? All right. Any questions about anything at all so far? Okay. Just a whole lot of no's tonight, which is fine. All right, cool. Let's go on to question 5. Okay. So
Professor, can
this
I
is,
ask a question about the essays?
yeah.
Or should I- Okay. You had said, by the way, this is Alex. Just wondering, you had said that
Well,
there
yeah.
should be a negligence per se in the beginning if there's more than one, or if that's just an overall blanket for at least one of the defendants.
No. So what I said was if you have negligence per se, so say you have multiple. This will come up in the essay that we're doing tonight. So if you've done that essay, you'll see how it plays out.
Oh, okay.
Yeah.
Yeah, I haven't, but I'll
Okay.
just wait till we get there then.
Okay. But I hope you guys have all looked at the two essays that we are going over tonight because I'm not going to give time to sit and go through them, or to sit for you guys to do them unless like nobody's done them. Um. So okay. Um. All right. So question 5. This one is a tricky one for a lot of people. So, and this is really just because like this question is good because it shows like the level of depth that you have to know for some of these MBE problems. So first, we read the call. If the mother files suit on her son's behalf seeking damages from the father for false imprisonment, who will prevail? So you want to list out the elements of false imprisonment. So so you do that on the top of your page. So I hope you guys have written that out. And then and then you go through the fact pattern, and you're looking to see if those elements are met. So after a bitter custody battle, the court dissolving a marriage ordered that the mother had sole custody of her 3-year-old son. So the mom has sole custody. The father was allowed to have his son for visitation purposes, which included 2 weeks every summer. Okay. During the first summer visitation, so what I'm expecting is the father has visitation, but he's not going to give the kid back. So it's, kidnapping, right? But it's not criminal law. And that brings up, so this is the second time where there's something that looks like it could be something criminal, but we're in torts. So, that's another reason that it helps to read the call of the question because it can help identify what subject you're in. Whether you're in torts or you're in criminal law, because criminal laws can always say, the prosecution charges, or, to ask if somebody can be convicted. Here it's, in torts, you obviously have like two private individuals. So, during the first summer visitation period, the father took his son to stay with the father's parents. When the 2-week period ended, both the father and his son disappeared from sight. So this is exactly what we thought was going to happen. Um, Under an assumed name, the father leased a poultry farm in a rural area and kept his son there. All right. Um, his son enjoyed living on the farm and helping collect eggs and doing other activities with his dad. So I'm thinking about false imprisonment here, and the mom's asserting the claim for false imprisonment. And the thing about this fact pattern is that the son seems happy. He seems happy. He doesn't necessarily seem confined to a bounded area, or that he's like that it's against his will in per se. Um, but the mother obviously is going to be frantic in this situation. So the mother tried to find the father, but was unable to learn of his whereabouts. 2 years after the son and the father's disappearance, one of the neighbors saw the son's picture in a television program about missing children. The neighbor notified local police, and the son and his mother were reunited. So, if the mother files suit on her son's behalf seeking damages from the father for false imprisonment, who will prevail? Um, so here, for false imprisonment, you don't. So generally speaking, false imprisonment, you have to be aware of the confinement, and it really seemed like here the son was not aware of his confinement. But there's an exception, and the exception is that you don't have to be aware of the confinement if you're actually injured by it. So here, there is an actual injury because he was supposed to be taken care of by his mother, because that is what the court ordered, and he was not being taken care of for his mother. This particular question, people just like they actually think that the bar and Barbary got it wrong on this particular question, but this is how the bar examiners look at this. So like in this instance, not being taken care of by your mother, um, when she was the court ordered sole provider for those 2 years, court ordered sole provider, and then he was not in her care for 2 years, that is an injury that the son suffered. So this is just straight up knowing the rule. So the son, because the father did not have legal custody of him, that's not a basis for false imprisonment. You still have to show the elements. And here you still have the issue of, we don't know, of the son not being aware of his confinement. B, the son, because the father deprived him of his mother care for 2 years. So that actually is an injury suffered by the son. But that's not a conclusion that probably came naturally to a lot of you. You'd have to really go through this process of elimination. So be careful if you really can't explain to yourself, or if you really can't justify why you're eliminating something, don't eliminate it just yet. Like we want you to know why you're eliminating something and have a reason for doing so. And also that way, when you eliminate the wrong thing, you can say, okay, well, you can identify where in your reasoning you were off. All right. So C, the father because the son did not realize he was confined. So that's your red herring. That's the one where that's your red herring answer. If you didn't know that this exception existed, then that's what you would have picked. And then D, the father because the son enjoyed living on the farm. Again, that's just not related to any of the elements of false imprisonment. So, and it sort of gets to he's unaware, but there's other answers. Like if you were between C and D, C is better because it incorporates both the law and the facts, because it's the son did not realize that he was confined, and that's just a more precise statement than D. All right, any questions on number 5? Okie doke. All right. Let's look at number 6. So we have an electrical engineer, we'll read the call. So in a claim for indemnity against the engineer, will the manufacturer prevail? So, all right, so it's an indemnity claim. A lot of you guys, I don't think this is something that's really heavily covered, but indemnity is obviously when you get, you see a lot of indemnity agreements between like a property management company and a homeowner or a landlord. So like if I own a property and I hire a property management company, the homeowner usually has to indemnify the property management company for any injuries arising from like a lease. So there's indemnity. So an electrical engineer designed an electronic game. So as soon as I see design an electronic game, I'm thinking, okay, is there a defect here? Because it's as soon as I see a product and someone designed something, I'm thinking, okay, is there a design defect? The engineer entered into a licensing agreement with the manufacturer, under which it agreed to manufacture the game according to the engineer's specifications and to market it and pay a royalty to the engineer. So here, the engineer is saying you have to make it according to my specifications. You have to market it and you have to pay me royalties. So the engineer really has been in charge of the design. So a girl whose parents had purchased the game for her was injured while playing with the game. So then you have to ask yourself, is this person the correct plaintiff? So even though she didn't purchase it, she was one that was, she was an expected user of it. Her parents had purchased the game for her, and she was injured while playing with the game. Then you have the girl recovered a judgment against the manufacturer. So you're thinking, okay, well, what's the manufacturer's liability? On the basis of a finding that the game was defective because of the engineer's improper design. So it's strict liability against the manufacturer here. And then the question is, okay, well, can the manufacturer then turn around and collect from the electrical engineer? And the answer is yes. But evidence was also presented that the manufacturer could have discovered the defect by reasonable inspection. So that's where it throws like a little bit of a wild hair in here. Is just because like, all right, well, they were negligent as well because they could have discovered it by reasonable inspection. So then that's where people, I think, start to doubt themselves if they miss this particular question. So in a claim for indemnity against the engineer, will the manufacturer prevail? So in here, the thing to also pay attention to, which I didn't highlight, but the game was defective because of the engineer's improper design. So that's the basis, is that it was really, it's the improper design. So you're looking, okay, well, it seems like the electrical engineer is really at fault here because the electrical engineer designed it. And the manufacturer agrees to manufacture it according to the specifications. So in a claim for indemnity, will the manufacturer prevail? So this is another instance where you've got to just know this rule. So between the engineer and the manufacturer, the engineer was responsible for the design of the game. And the rule here is just when you're looking at indemnity, if one party is significantly more responsible for it, then that party is responsible for then they have to indemnify. So, and the rule is explained in the answer explanation, but that's essentially it. So it's logical because here the electrical engineer was absolutely responsible for the design, so he should be responsible for the damages it caused. B, yes, because the manufacturer and the engineer were joint tortfeasors. That's not the reason why the manufacturer should be able to claim indemnity. If that were the case, then they could just get contribution, get contribution, not necessarily indemnity for the claim. C, no, because the manufacturer was strictly liable to the girl. So C is incorrect because even though the manufacturer is strictly liable to the girl, that doesn't mean that it's going to absolve the electrical engineer from its potential indemnity liability. So the manufacturer might have to pay the damages, it might be found strictly liable, but then the manufacturer can go after the electrical engineer. So that's fine. And D, no, because the manufacturer, by reasonable inspection, could have discovered the defect in the design of the game. And that's not a reason, again, that's just not a reason for the manufacturer to not be able to go after the engineer for indemnity. And, I think like for this, it's the policy behind it. We wouldn't want the onus to be entirely on the manufacturer. You want everybody to operate carefully. So A is the correct answer. And this is really just kind of knowing that little rule. So here, in going over this, I don't think that, if you've listened to your lectures, for Barbary or Kaplan or Themis, if you've listened to your lectures on torts, they probably haven't gone over all these little rules. And the reason they haven't is because they're expecting you to learn all these little rules by doing the problems, and reading the answer explanations and pulling these rules out. So it's important, which I'm sure you guys all know, but I just like to reiterate it here. But this is why it's so important to really go in depth and spend time in the answer explanations. Is because you're going to get a lot of law knowledge, like substantive law knowledge, just from reading the answer explanations. And like every time you come across a rule you didn't know, add it to a flashcard, or add it somewhere, so that you will be able to find it, and test yourself on it, and review it later. So, all right, any questions about that, or else we'll move on to question 7. Okay, cool. Thanks, Martha. All right, so question 7. It's a fun one. Whenever I see math, I'm like, hooray, right? All right, how much will the woman recover in damages from the driver of the car? So I'm like, all right, so this is calculation. It's not too bad, though. Usually, so when you have to do calculations in the bar, if you get something wacky, like in essays and MBEs and anything, if you get a weird number that's like not round, you messed up. They're going to give you easy things that you can just do in your head, hopefully. But this one, I think you guys can do. So a woman was crossing the street at a crosswalk, but did not look both ways. The woman was, so she's, bad on her, right? Contributory negligence. So the woman was hit by a truck, and immediately afterwards she was struck by a car. All right, so really bad luck. Because she's hit by a truck and then hit by a car. So there's two defendants there that hit her. So joint and several liability. As a result of these collisions, and this is where the cause, it's going to be the substantial factor test would probably come into play here. As a result of these collisions with the vehicles, the woman suffered severe injuries, obviously. Although it was impossible to determine which portion of the woman's injuries were caused by the driver of the car and which was caused by the truck driver, at the trial of the woman's suit, the jury determined that the driver of the car was 20% negligent, that the truck driver was 40% negligent, and that the woman was 40% negligent. So the woman's 40% negligent, so she can't recover for her own negligence. It was further determined that the woman had suffered $100,000 in damages. The woman had, so it's $100,000. She suffered $40,000, or she caused 40%, so she can recover $60,000. That's it. That's what she can recover. The woman had already received $10,000 from her group medical insurance plan. That doesn't matter. They're trying to throw you off with that. Don't fall for it. The driver of the car had a $500,000 auto liability insurance policy. Don't let that throw you off either. It doesn't matter. And the truck driver is now insolvent. That also doesn't matter. So how much will the woman recover in damages from the driver of the car? So remember, they're jointly and severally liable. So the driver of the car is completely responsible for it. So how much will she recover from the driver of the car? $60,000. That's what she can recover. I think this question is, my one qualm with this question is it says how much will the woman recover instead of how much can the woman recover. So I think language-wise it could be a little more specific, but it's $60,000 because that's what she is entitled to recover from the driver of the car, despite the fact that he was 20% negligent. And not, because then the driver of the car could then go after, or the driver of the car had a $500,000. Oh, actually, I'm sorry. I read that a little bit off. So the driver of the car had a $500,000. So yeah, she will recover the $60,000 from the driver, and the truck driver, I mixed those two up. I'm sorry. The truck driver is now insolvent, so she will recover the $60,000 from the driver of the car, and then the driver of the car can also sue the truck driver as well to get contribution. All right, sorry. Now that I cleared that little snafu, I apologize for that. But any questions on that? Okay, thanks, Lori. Anybody else have any questions about torts MBE so far? Are y'all good? Okay. Hi, Vanessa. And Diana again. Okay, cool. All right. So, question 8. Will the friend prevail? This really gives us no information, so we just got to jump into the fact pattern. So, a man was negligently driving down the road, not paying attention to where he was going. So he's driving, negligently. So you always want to pay attention to really significant words like that. Negligence, they're telling you he's negligent. Because of this, so there's causation, he hit and seriously injured, there's injuries, so there's damages, a pedestrian who was lawfully crossing the street. Okay, so somebody's crossing the street. That's bad. But it doesn't really seem like it's going to be a negligence problem because it's already been basically established by the facts. So the accident was witnessed. As soon as I see a witness, I'm thinking NIED, and then you think of the rules for NIED and who can recover. So the accident was witnessed by a friend of the woman who was standing on the sidewalk. As soon as I see that it's a friend, I'm like, okay, well, this person can't recover because you have to be a close relative. The friend suffered extreme emotional distress that physically affected her nervous system. Okay, so suffered what you have to suffer to recover for NIED, but still you're a friend. The friend brings suit against the driver for negligent infliction of emotional distress. Okay, so they actually do tell us here. In a jurisdiction that's adopted the majority approach in bystander cases. So the majority approach is that you have to be a close relative. So will the friend prevail? I know the answer is no because it's a friend, not a close relative. So D is our correct answer, but let's go through A, B, and C. Yes, because she witnessed a pedestrian being seriously injured by the driver. That doesn't matter because you still don't have the element of being a close relative satisfied. B, yes, because severe shock constitutes a physical injury. So this is just stating other elements that are met, but you have one element that's not met, so these can't be correct. C, no, because she was not crossing the street with the pedestrian. You don't have to be that close by either. So, all right, and then we have D, which is the correct answer. Any questions about that? I'm going to assume no. Okay, cool. All right, let's look at 9 and 10, and then I'm going to take a short break because I need to get some more Gatorade. I said to people at the very beginning, get your flu shots. It's not fun. It's really bad this year. So we'll get through these 2 questions, and then we'll take a little break, and I'll let you guys, and then we'll talk about the essays. Excuse me. All right. So call the question. If the nurse asserts a claim based on defamation against the doctor, will the nurse prevail? So again, it tells us defamation here. So we want to think, okay, well, this is a nurse and a doctor. It's nothing, generally speaking, I'm going to assume that it's, because it's a regular doctor. Unless anything tells me they're famous, I think, and it's the nurse. So I'm just going to assume it's a regular, private, standard defamation claim. So after being notified by a doctor that her employment with his office was terminated, a nurse applied for a position with the hospital. So I'm like, all right, well, oftentimes what you'll see when you have a defamation case and its employment, you're going to see the defense of consent. So that's what you want to watch for. So defense of consent, that you consented to something being disclosed about you. So, but that the way that works is a little bit nuanced. So you need to understand. But let's see if it applies here. So in her application, the nurse listed her former employment with the doctor, with the understanding that the doctor might be contacted. So just because somebody might be contacted doesn't mean that you consent to them, saying anything negative about you or just saying anything negative. The doctor, in response to a telephone inquiry from the hospital, stated that the nurse lacked professional competence. Okay, so he says that's obviously bad, and it's bad regarding her profession. So I'm sure, she's displeased. Obviously, she's suing him for defamation. Although the doctor reasonably believed that to be a fair assessment of the nurse, his adverse rating was based on an episode of sorry, let me start that sentence over. Although the doctor reasonably believed that to be a fair assessment of the nurse, His adverse rating was based on an episode of malpractice for which he blamed the nurse, but which in fact was chargeable to another doctor. So the nurse didn't do what this doctor thought. So the doctor's wrong, but he had a reasonable belief for it. Because of the doctor's adverse comment on her qualifications, the nurse was not employed by the hospital, so she suffered damages. So if the nurse asserts a claim based on defamation against a doctor, will the nurse prevail? And so here the trick is they're going to try to get you to say that she consented, but this isn't consent. So just because you consent to that you understand that somebody might call, that's not consent for them to necessarily say something to this extent. So don't, that's the trap that they were looking for you to fall in. But really it's the nurse will not prevail because the doctor had a reasonable grounds for his belief. So you always, again, want to pay attention to those, legal terms of art, if it tells you what they believed, whether that belief was reasonable. So here it says the doctor reasonably believed. So A, yes, because the doctor was mistaken in the facts on which he based his opinion of the nurse's competence. That doesn't matter. The nurse will not prevail based on that because he can have a mistake so long as his belief was reasonable. So A is incorrect. So B, yes, because the doctor's statement reflected adversely on the nurse's professional competence. So just because it reflects adversely doesn't mean that it amounts to defamation as long as he had a reasonable belief for it. C, no, because the nurse authorized the hospital to make inquiry of her former employer. So just because you understand that the doctor might be contacted, that doesn't mean that you consent to something like this statement. So you have to know the distinction between, an authorization to check to see if she actually worked there, and then and then the consent that's allowed for defamation. So you will see a variation of this fact pattern throughout studying, and I want you to pay attention to it. And then D, no, because the doctor had reasonable grounds for his belief that the nurse was not competent. And that's correct. He did have, the facts tell us that he had a reasonable grounds for his belief. So D is the correct answer. All right. And then question 10. So a bill collector for a store came to a consumer's house at 7 p.m. on a summer evening while many of the consumer's neighbors were seated on their porches. When the consumer opened the door, the bill collector, who was standing just outside the door, raised an electrically amplified bullhorn to his mouth in a voice that could be heard a block away. Or raised a bullhorn to his mouth. Sorry, is somebody's like breathing heavily that just called in. All right. So in a voice that could be heard a block away, the bill collector called the consumer a deadbeat, right? So that's bad. Nobody wants to be called a deadbeat. And then this is also embarrassing because it's 7 p.m. It's a summer evening, and there's a lot of people around, so a lot of people are going to hear it. So again, this looks like, and it says in the call to question, this defamation. And asked him when he intended to pay his bills to the store. So this is defamation. This is spoken, so this is slander. And when it's written, damages are presumed, right? But with when it's spoken, then you actually do have to show some damage. So we're going to have to show that here. In fact, the consumer did not owe any money to the store. So if the consumer asserts a claim based on defamation against the bill collector and prevails, what is the most likely reason? So here again, this is a long, convoluted question, I think. But all you can just say is, why will the consumer win? And the consumer will win if they can show that they suffer damages. That's it. So that's the only element that's really missing. So we know that issue because it's, everything else, they're saying something that's going to have a negative feeling. It's published to other people, to a third party, because neighbors can hear it. Calling somebody a deadbeat, calling them, a name. This doesn't fall into any of those other of the strict, the strict categories for defamation. Loathsome disease, something reflecting on the professional character, etc. So you do have to show the damage here, and that's the only thing that's really missing. So that's what we're looking for in the answers. So A, the bill collector was negligent in failing to discover that the consumer owed no money to the store. That doesn't matter. You don't have to prove negligence. B, the bill collector's conduct was extreme and outrageous. That obviously gets to IIED. That's not related to defamation. C, the bill collector knew that the consumer owed no money to the store. Even if that's true, it wouldn't matter if the consumer didn't suffer some sort of damage. So then D is our correct answer. So the consumer suffered some pecuniary damage. All right. Any questions about any of those, or about torts MBEs in general? So not so bad. I don't think with this set, but it does show. I think some of the areas that you guys kind of need to look for. It shows some variations in the fact pattern. So it gave you, a few different defamation things. So it's testing defamation a few different ways. It also shows. Um, it also shows. Oh, what was I going to say? Um, just the level of depth that you have to know. Some lesser known exceptions and some lesser known rules. Um, so it just shows that level of depth, and it said, this is how they are teaching you some of those rules. Because one of the things that I hear a lot is, okay, well, they never talked about this, and they will not. They will not talk about everything in the lectures, and so it's just really up to you guys to make sure that you're doing a really solid, thorough review um, of all of the answer explanations. All right, so that's it for the MBE portion. I want to go over the essay questions. So we're going to start with the first one, which is the Darla is in the, sorry, give me one second. Which is the Darla is in the pest control business question. And let's see. So do you guys want a few minutes to review that question? Okay. So it's posted to Twin. So if you guys want to, here actually, let me do this. I will give you guys, let's see. It's Torts 2. I'm going to start with that one. It's Torts 2. I'll give you guys like 15 minutes. Does that sound good? So till 7:05? It's just under 15 minutes. Okay, cool. So go through it, try to outline it, etc. All right, was that enough time for you guys? Or do you need more? This one is a pretty intense, despite it being a short little fact pattern. There's a lot of issues built into it. So okay, cool. All right. So first thing, you read the call to question, then you make your list A. So here we have, is Darla liable to Paul? If so, may Paul obtain damages from Darla for fear of contracting cancer? So it doesn't necessarily tell us we're in torts other than me telling you that you're in torts. So generally speaking, you want to look directly above, but this fact pattern is so short. You might just, you could do a couple of things. So it's obviously, is one person being liable to the other. And then it's asking for damages for fear of contracting cancer. And that really does kind of scream torts, but some people might not have eliminated other subjects. But so I would definitely make my list A for torts. Let me actually pull up my list. Okay. Okay. So sorry, I don't know who's caller 5. Okay, there, that's better. Okay, so I made my list A. So for torts, so I have negligence, products liability, intentional torts, dignitary interest. So it's, privacy torts, defamation, strict liability. What else can you guys think of that are intentional torts? Anything else? No? Does that cover it for you guys? Well, intentional torts, yeah, so battery. Right, so I have intentional torts on here. So if you guys can see my screen here. So here's my list A. And then this is going to be my list B. Okay. So it looks like, yeah, so that's intentional torts, yeah. So I just group everything. I just figure, oh yeah, nuisance. I knew that was the one that I was looking for. Thanks, Vanessa. I knew there was something I was missing. So I'm going to go through this. So I've listed out, so I read the calls. I listed out my list A. Then I'm going to go through the fact pattern. So Darla's in the pest control business. So as soon as I see pest control, I'm like, all right, well, that often contains really dangerous chemicals. So I'm thinking about normally dangerous activities and strict liability. She develops and produces fumigation gas for her own use. She also sells the gas to consumers. So there I'm thinking product liability. So I'm thinking, okay, strict product liability because she manufactures it and sells it. And then anytime you see product liability, you can always do a negligent product liability as well. And it says some of her competitors do not sell gas to consumers because consumers sometimes do not follow safety instructions. So this is giving us, what would a reasonably prudent, pest control business owner do. So this tells us, if there's the duty, the standard of care, and that she's probably breaching it. So now we have Darla sold a container of fumigation gas to Albert for use in ridding his apartment of insects. All right. So she sells it to him for the purpose of getting rid of his insects, which is exactly what it's supposed to be used for. Although she had intended to produce gas of standard toxicity, she had unknowingly produced gas of unduly high toxicity. So that looks like it's a manufacturing defect. So it looks like this is definitely a product liability problem. Albert used the gas and succeeded in killing all the insects in his apartment. Okay. Because he used the gas carelessly, so he looks like there might be a contributory negligence analysis here. Some made its way into the apartment of his neighbor, Paul. All right, so then Paul's our plaintiff. The gas caused Paul to suffer serious lung damage and to fear that he would contract cancer as a result. All right, so the super short fact pattern. This is, I wouldn't say this isn't atypical, but I think it's like on the shorter end. So then I'm going to run through my list A and I'm going to think of, okay, well, what are the things that this is really wanting me to analyze? So I'm like, all right, well, I think that there's, is she liable in negligence? I think, strict product, or I think product liability and negligence claim, yes. So I'm like, all right, so negligence, there's product liability, so there's strict and there's negligent. I don't see any intentional torts really at issue here. I don't see privacy defamation. I do see strict liability because it's abnormally dangerous activity. I don't really see there. You could maybe actually make a nuisance claim, a private nuisance claim. You could do that. I actually don't think I include that on my model answer, but that is something that's possible here that really didn't actually occur to me until right now. This is why having the list A helps. Like I had forgotten about nuisance, and now that it's there, I'm like, oh well, okay, well maybe that's an issue too. So I think you actually could potentially include that as well. All right. So first, I think, okay, well, strict liability. So then what I'm going to do is I'm going to make my list B, and I'm going to go through and I'm going to list out all the claims and the elements. So that's what I've done here. So this is pretty, like, fairly exhaustive. The answer that I wrote for this one is fairly long. So we have strict liability. I list the elements. So it's got to be an abnormally dangerous activity. So it's abnormally dangerous if there's a substantial risk despite the exercise of reasonable care, and it's not a matter of common usage. Did the harm result from the normally dangerous propensity of the activity? Then is there causation, both actual and proximate, damages, defenses, and assumption of risk? And then I did product liability. So strict product liability, so commercial supplier, production or sale of a defective product. So here I'm really looking at a manufacturing defect, not a design or a warning defect probably, but I list them all. Causation, again, actual, proximate, damages, defenses, then negligent product liability. So you're just going to go through the whole full-blown negligence analysis. So duty, you do Andrews and Cardozo, what's the standard of care? Breach. Here, you want to think of like all of the different potential ways of showing breach. I included, the one in my answer that I included was res ipsa, so I did list that here, but you would think of breach, you might think of, learned in hand, res ipsa, obviously just standard breach of RPP. So you list that, and then you have causation, both actual and proximate, damages and defenses. I also included a couple of extra things, so implied warranties and merchantability, and fitness for a particular purpose. And so, yeah, merchantability, fitness for a particular purpose. So I included those as other ways, just, other avenues you could go down, in terms to collect. Because when you're on a bar exam, you want to think, okay, well, what are all the different possible ways that I can go after this particular individual? Which is really how that's how, pursuing liability, works. You're going to put out all the different potential claims, all the different theories. So these are just some other ones. So this is, this is really Albert. Albert can probably bring these. So these are a bit attenuated. So I don't know that you would necessarily get the implied warranties, but I have them here, and just in case any of you did get them. And then, talking about fear of contracting cancer, that's a really small issue, then we'll get to it. So what I want to do is go through and just match up the facts. So abnormally dangerous activity. So substantial risk despite the exercise of reasonable care. So is there a substantial risk despite the exercise of reasonable care? Yeah, it's, or I would just say yes. It's fumigation gas. And it seems like it's toxic, right? So it's highly toxic. Others don't sell it. Others do not sell because consumers sometimes don't follow safety instructions. So I want to list out as many facts as I can here. Even if you have one fact and it's satisfied, fine. But you want to use all the facts. One of the big things in getting from a 60 to a 65 is using every fact in here. So we're looking for that. So matter of common usage. So is this something that's a matter of common usage? Selling and producing fumigation gas. So it doesn't look like it is in a commercial manner like this. It looks like you would generally hire someone to come in and do this. You would hire somebody in the pest control business. So not a matter of common usage. So can somebody tell me why? I just want to hear what you guys thought. Yeah, exactly. Yeah. I think, Eric, you're spot on. Yeah, nobody else sells it. It's not a matter of common usage. Good. So that's how you use that. That's where you use that fact also. Good. Good, good. Or it says some of her competitors don't. So, okay. So did the harm result from the normally dangerous propensity? So this is, the harm has to come from, what you expect the thing to be dangerous for. So here you expect, gas to be toxic, right? And that's exactly what happens here. So gas equals toxic. This gas was unduly highly toxic, unduly high toxicity. Okay, so so here this is a yes. Causation, so actual cause. So this is just, but for causation. So, but for Darla selling the gas, would there have been the injury? So no, because, or would Paul have suffered because A would not have obtained gas, but for, and especially the unduly high gas. And then proximate cause. So here, is it for, so to answer the proximate cause question, is it foreseeable that someone is going to not follow the safety instructions or use it carelessly, as they say? Let's see. Yeah, right. So it's foreseeable because here, good. Hi, Christina. It's foreseeable because the competitors don't sell to consumers because consumers sometimes don't follow the safety instructions. Because sometimes, because okay, good. Good. So, and is it, and so that's why the fact that Albert used it carelessly doesn't cut off causation. So, but you need to address that. So I'd say, but Albert was, so Albert was careless. So I wouldn't say that, but so that's just the other fact is that Albert was careless, right? But that's foreseeable. Okay. Did Paul suffer damages? Yes, because Paul, he suffered serious lung damage, and then he also fears that he will contract cancer. So, suffers serious lung damage and fear of cancer. All right. Is there anything you can say, like assumption of risk, anything like that here? Oh, it is. Sorry. It's but for, so it's sorry, it's yes. I was saying yes, it's, A would not have attained. But yeah, so here, it just should say yes. Sorry, I was just being a little inconsistent there. Okay. But so voluntarily bought the gas, but it's Paul is the one that was injured, right? So Paul didn't voluntarily do anything. Paul was just next door. So there's no defenses that apply to Paul. I just listed him. Oops. Okay. So overall, then, does it look like? So it is an abnormally dangerous activity. It's not a matter of common usage. The harm results here, yes. Here, so we have causation. We have damages, and then there are no defenses. So is he going to win on the strict liability claim? Yes. Okay, good. Okay, good. Products liability. So let's go through products liability. So first, so if you're a commercial, so for strict product liability, you can be a commercial supplier. So here, Darla is in the pest control business. She develops and produces fumigation gas and sells it to consumers. Okay, so she's a commercial supplier, yes. Is there a defective product? Yeah, so it's a manufacturing defect. So she intended to produce gas of standard toxicity. She unknowingly produced gas of unduly high toxicity. So unknowingly produced gas of unduly high. So it looks like there's just manufacturing. I don't see a design defect. I list these here just because I always list them when I'm like listing out my elements, but I don't see a design defect because I would think that, you know, she's in the pest control business, that she wouldn't do this intentionally. And it says she was unduly high. And it said she intended to produce gas of standard toxicity. So intended standard. You could make an argument. I mean, I list these here too, because like sometimes when you're going through, like you could make an argument there's not a warning, but I don't think this warning would have done anything to Paul either. So it's something, you know, something to think about. I think that some people did actually spend a little bit of time talking about the warning defect here, but it's not enough. You do have a manufacturing defect. Usually a warning defect is going to be a bit more obvious. And we gave for the July bar, the mock bar that we did had a pretty good fact pattern that did have a really good. If you're struggling with products liability, you should see Professor Matsumoto and ask him for the mock bar essay that we gave on products liability for July, because that one does cover some pretty good concepts, and it really is good for product liability. So I'd say no. So there's nothing about warnings at all. I think you could write about the fact that there could be a warning on the label, but that still wouldn't have done anything about the unduly high toxicity. So causation, so actual, we'll say yes. Yes, because injury caused by gas. Proximate, again, this is the foreseeability. Yes, because injury or careless application foreseeable, because consumers sometimes don't follow safety instructions. All right. Damages, again, he suffered, you know, and you can just copy defenses, and I don't think there's any actual defenses that apply here. Okay, so then we go to negligent product liability. Here, even though you've shown so here, Paul can recover under on a strict product liability theory. So make sure that when you're answering these questions, and like I said this earlier, you know, is Darla liable to Paul? Yeah, you want to show like how many different ways can Paul show that Darla is liable to him. So you're trying to show as many different ways here. So you have strict liability, you have strict product liability. So you have just strict liability for abdominally dangerous activity, then you have strict product liability, then you also have negligent product liability. So you want to show, you know, duty, standard of care, breach. So, you know, Andrews, Paul is a person. That's really all you have to show. Here you have to show that in Cardozo you have the zone of danger. So you have to say, okay, well, D created unduly high toxicity gas. D created the unduly high toxicity gas. So that's what D did that was negligent. Paul was within the zone of danger because he was next door. I think he was, yeah. So yeah, so where is the zone of danger? So zone of danger is anywhere the gas could get, I would say seep, because gas like seeps through the air to me. So standard of care. So a reasonably prudent person. So a reasonably prudent person probably would not sell gas to consumers. So like this here, I think is really obvious. So our RPP would not sell gas to consumers. So is there a breach? I would just say, yeah. I would say, yes, because D sold gas to a consumer, and RPP would not have. So it's simple. You could also say here, like with res ipsa, that an injury like this would not have occurred but for the absence of negligence. So you can definitely use that here as well. So you can use, this is like, res ipsa doesn't come up very often on the bar, but this is an instance where you can actually use that theory to show that there is a breach. So would have, it doesn't occur in the essays very much. It does occur in the MBEs, but or in the absence of negligence. All right, so causation, this is really going to be the same as above. So actual and proximate is the same. So I'm actually just going to write same. Damages, again, I'm just going to say same. The defenses, no defenses apply. All right, so again, so here you can show negligent product liability. So you can show how she could also be liable to Paul through a negligent product liability theory. And then two other things. So merchantability. So implied warranty of merchantability is because if you can show a breach, then you can recover damages these ways as well. So merchantability, so a merchant who deals in certain goods of kind sells such goods. Then there's an implied warranty that the goods are merchantable, which means that they're generally acceptable for those who deal in similar goods and generally fit for the ordinary purpose. So here I listed the rule out here. I didn't know if you guys all would have that. So I just wanted to break it down. So P is deals in fumigation gas and that's where you can use the fact that she's in the pest control business. So there is an implied warranty that the goods are merchantable. So it's implied warranty they're generally acceptable, and here they weren't. So not generally acceptable because unduly high toxicity. Because they're of unduly high toxicity. So and they're generally fit for the ordinary purpose for which their goods are used. And again, they're or fit for ordinary purpose. Because, so I mean, I guess you could say that it's fit for the ordinary purpose because it did kill all the insects, but it's unduly high. So that's not good. And then fitness. So I would say there is a breach of the implied warranty of merchantability. So you can recover there. And then fitness for a particular purpose. So seller knows or has reason to know that particular purpose for which the goods are required. So here, Darla probably knows that when she is selling them to Albert, what he's using them for, which is to kill pests. And he's relying, and also that he's using them in a residential area. So D likely knows that that A is buying for, because it says here, or it doesn't, we don't have to say likely. So D sold a container of fumigation gas, rid his apartment of, so she would know that there's people nearby. So she would know that. And he did rely on her to furnish a gas that's going to be okay to use in that type of environment. So I think that he did. So A it doesn't say explicitly, so I'm going to say likely, relied on D to sell a gas that was fit for area. So I think there's that too. So here, so then you can show breach this way as well. And then you can recover damages there as well. So those are two other ways to get to recovering damages and to liability. So then the fear of contracting cancer, I listed the rule here, and I'm going to post this sheet just so you guys have it, obviously. So here, the fear of contracting cancer. So I listed my rule. So plaintiffs has to show actual harm or injury. And once they do, then they be compensated for all their damages, economic and non-economic. So plaintiffs' non-economic damages include damages for any emotional distress suffered, which can include contracting cancer. So even though this seems really weird, it actually is possible. The plaintiffs, though, would have just a duty to take reasonable steps to mitigate. So probably needs to go to the doctor, maybe go see, seek psychiatric help, something like that, to help combat this issue. So, all right. So that is this particular essay. Any questions about that? Okay, so I want to point something out to you guys. So I started going back at this not that long ago, and I'm talking through it the entire time. So I've spent maybe 20 minutes or so going over this question a bit, and typing it out, and like going through it like this. I mean, I know that I had looked at it before, but just spending the 20 minutes, like I now can literally, and I've typed out my outline basically. I can go in and I can type out this entire answer. And this is hitting like everything. So then I would really have probably like 40 minutes left to type and just to like kind of get to work. So this is where I think pre-writing really helps because I've spotted everything. I've thought of all these different ways that I can attack this particular problem. So I wanted to just kind of point that out to you guys too. So it is really worth it to pre-write. It's worth it to go through this and to think about all of the answers, and how you're going to come in advance, and to also just see where you need to spend your time. If when you're doing this, you'll see that, it makes it a little bit easier to see where you do need to spend your time. Or maybe like this one actually is a little bit more evenly split up. It looks like product liability, like strict liability, each of the two product liability are going to take about the same amount of time, but you have these other two. If you got to the implied warranties, you'd have a little bit on those. And then really that second call really just didn't take much time at all. So it helps you, triage the call of the question. All right. So that's that question. And then the next one is a pure negligence fact pattern. So I will give you guys, I'm assuming you guys need time to go over that one as well. Is that correct? Okay. All right, let me give you that one that one's intense. That one is intense, and I know it very well because I was on my bar. So let me give you guys till 7:45. I'll check back in. All right, so let's get back. Okay, so this one is a crazy kind of racehorse torts problem that's all negligence. Um, oh, it's all negligence. Sorry, that was my dog. Um, and um, not too crazy, just because it's negligence, and most of us can handle negligence. But there is a lot that is there's just a lot of ground to cover since you have three defendants here. So that's really the thing to keep in mind for this particular problem. So first we're going to read the call of the question. So under what theory or theories, if any, might patron bring an action for negligence against caterer, waiter, and/or owner, and what is the likely outcome? Discuss. So it straight up tells us is that they just want negligence, which is great. But it's three negligence claims. So because of that, you're going to look for kind of different theories. You're going to look for different standards of care. You're going to look for negligence per se. So here we have owner owned and operated a small diner where cook and waiter worked. After closing one day, cook called in sick for the following day. Owner knew that an acquaintance caterer owned and operated a catering business. Owner asked caterer to fill in for cook. Owner told caterer, "I want you to run the kitchen for one day." Oh, sorry. It said negligence, so I've listed out just my negligence elements here on my scratch paper. So owner asked caterer to fill in for the cook. Owner told caterer, "I want you to run the kitchen for one day. I will pay you your standard catering fee. I just need somebody who knows what he's doing." Caterer agreed, telling owner, "I'll bring my own knife set, but I assume the kitchen is fully equipped." So here there's a few things are jumping out at me here. So first of all, you have somebody that's calling in sick. It calls an acquaintance caterer, owned and operates a catering business. So it looks like this is someone who can do this type of work. And the question comes up is, okay, well, are they an independent contractor or are they employee? So to the extent that they're going to be liable, that the diner or the owner is going to be liable for, I know that cook is going to act negligently. So I will pay you your standard catering fee. So it tells them they're going to pay the catering fee. Um, and caterer says, "I'll bring my own knife set." So they're using their own tools, but they're also using the kitchen that belongs to owner, or that's at the diner. So owner did not check caterer's references. So this looks sort of like that's a negligent thing that owner is doing. If he had, he would have learned that caterer's business had once been shut down by the health department. So that would have told owner a lot. Being shut down by the health department is pretty negative. I think it takes a lot to be shut down by the health department, shockingly. So caterer went to owner's diner and started to cook. Patron, a customer, ordered chicken wings from waiter. So obviously something's going to be wrong with the chicken wings. Waiter gave the order to caterer. So now you see that we have waiter. A notice posted on the kitchen wall entitled Health and Safety Code Section 300 Notification. So now we have a statute. So here's probably negligence per se is going to come into play. Stated, to avoid food poisoning, all poultry products must be cooked at a minimum temperature of 350 degrees. Upon observing that the oven was set at 250 degrees, waiter informed caterer that the oven should be set at 350. Caterer responded, "Just worry about waiting tables and leave the cooking to me." So here you have the question, okay, well, it seems like waiter knows that the chicken is undercooked, but is waiter going to do anything about it? Or is waiter going to actually serve the food, which is obviously a bad idea. But, if you're listening to, you trust that the person cooking the food is going to cook it properly, especially with a sign like that there. Caterer did not raise the temperature of the oven and remove the chicken wings shortly thereafter. Waiter served patron the chicken wings. So waiter does still serve the chicken wings. Patron ate the chicken wings and suffered food poisoning as a result. So under what theory or theories, if any, might patron bring an action for negligence against caterer, waiter, and or owner, and what's the likely outcome? So again, this is three negligence claims. You want to think of different theories for negligence, though. So you can think of negligent hiring. So you want to just think of regular negligence. And you want to think of, are there any, special ways you can get at this too? So negligent hiring, I think is one. So duty, let's go here. Okay, so first though, let's just kind of start. So what I'm going to do, I'm going to just copy this and we'll go through each of them. So duty. So for Let's start with caterer. So under Andrews, so patron is a person. So ode a duty, a person, and then Cardozo. So what is the negligent thing that that caterer did? So caterer is the one that did the cooking. So you want to think about this. So caterer is just the one that did the cooking. So you're going to be suing him individually. He's the one that actually did it. So he's probably just going to be not cooking it at the right temperature. And it's going to be just like really your standard negligence claim, probably for caterer, but also not cooking at the right temperature. So you're going to have negligence per se. Oh, Erica, it is. Is that better now? Oh, sorry, you guys. Thanks for telling me. Is it better now? Hold on one second. Play. Can you see it? Sorry, I just had to redo it. Okay, there. Now we're back in business. Okay, good. Sorry about that. Thanks for letting me know, Erica. I appreciate it. All right. So I have here, so P is a person. So then I want to think about, what is the negligent thing that caterer did? So what caterer did is he undercooked it. So what did he do that created, so under Cardozo, we're thinking about zone of danger. So how did his conduct create the zone of danger? So C, undercooked the food. Where is the zone of danger? It's anywhere, the food can be consumed. And patron ate the food in the restaurant, right? Ate food in restaurant. Okay, so the duty is owed under both. Under either. Okay, so what's the standard of care? Reasonably prudent person, right? So here, a reasonably prudent. So here you're staying objective. You're just identifying what would a reasonably prudent person have done. So a reasonably prudent caterer would have probably cooked at the proper temperature. Would have cooked at the proper temperature. And I think, and then on top of that, especially when there is a statute, that requires poultry cooked at 350. So, Ed, can you think of any other standard? Like some people on this particular fact pattern try to say that, professional, and I think you can make that argument. Generally, professional is something that's going to be like doctor or something like that. But I think you can definitely make it here. I don't think it's necessary though, and I don't know that you would really have time. But if you wanted to, you could do the argument for a professional standard of care here as well. So breach, I think so. I like separating out standard of care and breach like this. I think it makes it a lot easier to see. Not everybody does it that way, but I think it's a lot easier for the grader. I think it's a lot easier for you guys to make sure that you're not getting things kind of convoluted. So breach, so caterer did not cook at, it'd be helpful if I spelled cook right, he cooked at 250. 250, not 350. So he's in breach. Okay, causation. So actual and proximate. So actual causation. So but for him cooking them, undercooking the food. So I'm gonna say yes, but for C, undercooking, he would not have been injured, would not have suffered food poisoning. And I don't know if you guys just heard me do that. I said he would not have been injured, but then I went and I changed it to use the specific facts. And it's important that you use the specific facts and use them, how they're written. And you'll, it's something that takes practice, and you'll get better at correcting it over time. If you're not, great at doing it right now, that's normal. You do have enough time to like fix stuff like that, and you'll get used to it the more and more you write throughout this process. All right, and then okay, and then proximate. Okay, so here, so there's a proximate cause. So is it within the increased risk of undercooking food that someone's going to suffer food poisoning? Yes. So increased risk of undercooking is food poisoning. And is this within the increased type of harm? Yeah. So this is, so it's foreseeable. Sorry, I always forget this, and I know that when I've had you guys in class that I would forget this too. So within the increased risk, and I think it's within the increased risk of danger. So yeah. From undercooking is food poisoning. Okay. So yeah, so there's causation. So there's causation. Did he suffer damages? Yes. This is pretty easy. Yes, he suffered food poisoning. So, I mean, this is really just for caterer, and it's just a pretty straightforward negligence claim. Oh, sorry, first, caterer, we also have to do, so duty, we also have to do negligence per se because it applied. That's what applies to him. So, negligence per se. So, there has to be, oops. So you have the three elements, right? So is there a violation of an ordinance? So cooked, so type of person trying to protect, and type of harm trying to prevent. So violation of ordinance, so that's pretty obvious here. Yes, cooked at 250, not 350. So in here you have to draw some inferences, but they're trying to protect, consumers, protect consumers from exactly this, from food poisoning. And the type of harm is probably, getting sick from eating, from food poisoning. Illness from food poisoning. So is there negligence per se? So you can show duty and breach via negligence per se. NPS for duty and breach. So I wanted to show you this. So we still have a lot to go through, right? We have two entire additional defendants to go through. So on this particular fact pattern, what you might do, the best answers will do a full-blown negligence analysis, but there are definitely, if you look at baressays.com, there are some passing answers that did this essay that didn't go through the full, duty and breach analysis of like RPP and Anderson Cardoso. They just did negligence per se. So if you were, running out of time, that is, that's an example of where you might want to cut something that you would include if you had all the time in the world. But if you don't, and you need to be strategic, that you would cut out the regular duty breach. You would just replace it with negligence per se, then do causation and damages. And then, do you do any, and then any defenses too. Do you guys see any applicable defenses here? I'll take that as a no. Okay. All right. So then let's look at waiter. Okay. So waiter, it's kind of a bummer here because waiter gets kind of roped into it. I mean, I wouldn't be pleased with my waiter either. But I don't know. I guess I don't know why I feel bad for the waiter here. All right, so duty. So this is so you have to. This is why, like with Andrews, or I'm sorry, with Cardozo, you have to think about, okay, well, what is the negligent thing that this particular defendant did? Because it's different for each person. So here, so Andrews, this is, I'm just gonna write same as above. You need to like type it out, but this is my own internal notes. So I just want, you guys to get used to making your own notes. So that's what I would write. But I would still, my analysis would be complete. It wouldn't just say same. Cardozo. So, what is the negligent thing that, um, yeah, so vicarious liability. So vicarious liability, it applies to both waiters and caterers' conduct, but that is part of the analysis of owner. So owner actually has the biggest analysis here, which is one thing I want to get to because it's like the last call. And if you hadn't saved your time, like if you hadn't properly allocated your time, people would have been in a bad spot because they wouldn't have been able to get everything that was related to owner. But yeah, so there is vicarious. There, you do have to talk about vicarious liability. So I'll get to that in a second. Okay. Um, so all right. Andrews. Okay. So with the negligent thing that waiter did, so waiter knowingly served undercooked food. Uh, Actually, I'm gonna say likely. And the only reason that I'm saying likely here is because, he says it to this caterer guy. It's like, shouldn't it be at 350? And the caterer says, worry about rating tables, leave the cooking to me. So maybe the waiter thought, well, okay, maybe caterer knows what he's doing. He's the one that's cooking the food. So leave it alone. And that could absolutely be the case here. So that's what I'm saying, likely knowingly served undercooked food. But he still served it, right? So that was the negligent thing that the waiter did, was serve undercooked food. So the zone of danger, and then I'm gonna say the zone of danger is the same as above. It's just the negligent conduct that's different. So standard of care here is really just a reasonably prudent waiter. So what a reasonably prudent waiter probably would not serve undercooked food. A prudent waiter would not serve undercooked food. I don't think there's any special standard here. So here, waiter breached probably. Yes. Waiter served undercooked food despite knowing it was undercooked. Causation, actual and proximate. So here I think that there is an issue, a little bit of an issue with proximate cause. Because, like this one is just, it's a little bit harder, is it? I still think that I'm probably going to say a yes, but I think there's a counter argument because it's really on caterer. Caterer is the one that did it, but a waiter could have just said, no, I'm not going to serve this because he knew that it was undercooked. But I think that here you want to probably make a counter argument. So, so let's do actual cause. So, but for waiter serving food, he would not have suffered food poisoning. And it also says here, P suffered food poisoning as a result. So it is a direct result. So that shows actual cause too. And then proximate cause. So, I'm going to say here, waiter served the food, still say likely, knew it was undercooked. But caterer served it, and caterer is the expert. So I think, so that's my counter argument. So that for me is telling me that I need to spend a little bit more time there. And I put an asterisk next to my counter argument so that I know that I need to spend a little bit more time there. But I still do think that, probably yes on both. But I think you could go either way, I think, on waiter. Maybe, I've had people that have pretty strong opinions that waiter shouldn't be liable or that he's not liable or whatever. And then, so I think you can maybe make an argument for proximate cause here, but I think so long as you include a counter argument, I think that you're okay. And then damages, I'm just going to say same. Okay. And now we get to owner. So owner has a couple of different things. So yeah, there's vicarious liability. Actually, let me pull up. I'll pull up my model answer to show you guys. Oops, I did not mean to show you guys me, because I have the flu and you don't need to see that. Let's see. Give me 1 second. I'm going to pause that. Oh, shoot. Okay. Okay, so I have my model answer that I've written up here. Um, so um, here, so this is for caterers. So same with Cardozo. So the zone of danger is the restaurant again. So we have that. The standard of care is what is a reasonably prudent business. So that's what you'd want to do. Is reasonably prudent business. Then you also have breach. So reasonably prudent restaurant owner. So you have breach, causation, actual, proximate. But then you're going to get into the vicarious liability or the respondeat superior issues. So that's where you get into the whole employee versus independent contractor. And you're going to look at whether the court will find that the caterer is an employee or an independent contractor. So that's where the vicarious, like Christina, you asked about, the vicarious liability comes up. So where courts assess in the totality whether someone's independent or an employee, and then they look at these factors: the party's intent, the form of payment, use of own tools and facilities, whether the agent has discretion in the method used to complete the task, whether the agent must work on the assigned project at a certain time. So here there are a lot of different facts about that. Let me pull up I don't want to go through the entire, negligence analysis. I want to focus more on the vicarious liability piece, the respondeat superior. I want to put this up here. So you have parties, so employee versus independent contractor. So you have tools, facilities, agent discretion in the method. And then discretion in time. To work on project. So let's look at the fact pattern here for that. So the party's intent. So I don't think there's anything that really shows their intent. I don't think there's any facts. At least not explicitly. So I don't think anything here is going to change that. The form of payment is standard catering fee. So he's not paying him what he pays, he's paying him what the guy would get paid as a caterer. So this might go more towards him being an independent contractor versus an employee, because an employee is probably going to get paid less. So I'm going to say it leans toward independent contractor because employee might be paid less. They usually are, because they get all the other benefits, tools and facilities. So, a caterer, like, I probably watch just too much Top Chef, but like, I know that a chef's knives are like, those are their tools. Like, that's their big tool that chefs have. So, but everything else, the owner is supplying. So here you're working in the owner's kitchen, but and using all of the owner's tools. So I think that's actually, there's a counter argument. I think you could really go either way on this one. So, Caterer brings own tools, but uses fully equipped kitchen of owner. So I think this is a bit of a toss-up, but I'm gonna lean actually towards this being an employee because he's doing it on site. So I'm gonna say that agent discretion and method. I don't think that there's I want you to run the kitchen for a day. So he still has to probably run the kitchen. He probably still has to run the kitchen and do the stuff that the owner wants. They have to cook the food that's on the menu. Likely has to cook food on the menu, right? Because it's at a diner, which likely has a set menu, right? So that's an area where you're going to want to draw an inference. So I'm going to say this way is being viewed as an employee. Discretion and when to work on the project. So run the kitchen for 1 day. So it doesn't look like there is any discretion for that specific day and when owner needs it, not at caterer's discretion. All right, so all of this, and remember too that when you're weighing factors like this, just because there's more factors that weigh in favor of one versus another, doesn't mean that it's conclusive, but it is indicative. But here I would say, looking at all of them together, the fact that he is at the diner, probably cooking what the diner wants, there's also like waiter serving the food, using the fully equipped kitchen at the diner. All of those things probably make it more likely that the court will find that it is caterer is an employee for the day and not an independent contractor, which means that owner will be liable for the negligence of caterer. So I will say court, and I'm going to put my conclusion in, court likely to find EE and owner liable. It doesn't mean, caterer is still caterer's probably still liable as well, because he himself was negligent, but owner is probably going to be liable. All right, and then the other thing I will say is there's also, and the other thing I want to say is just in terms of the negligence action, the negligent thing really that he did was, it was the negligent, some people actually spell out and do a negligent hiring claim, but it's really negligence it's really just like a regular negligence claim, and the negligent conduct was failing to check the references. But there's a counter argument to be made because he says, I just need someone who knows what he's doing. All right. So any questions on this particular essay? Okay, thanks. All right, so I have a question. So I mentioned at the beginning, so I was going to finish going over the property stuff. It definitely doesn't look like I have enough time to go over. Yeah, I will post, I'm going to email my copy of these notes. Oh yeah, Lori, that's a really good question. So you would mention in vicarious liability that owner is going to be liable for waiter's conduct because, and there, waiter is really obviously an employee, so you don't have to go through this whole analysis. Like the bulk of the analysis under responding superior is under caterer because that's where there is the ambiguity. But yeah, you would say that he's also liable for. So I actually would have two sections under owner, so liability for caterer and liability for waiter. And I would just have my analysis under waiter just be, here or an employer is liable for the acts of its employees. Here, waiter is an employee as established above. Waiter was negligent, and thus owner is going to be liable for waiter's negligence. Does that make sense, Lori? Um, um, I think that the selected answers will be posted. I do have answers that I've written, but I have to go through and like redact some stuff off. I have to like take off my sort of imaging and stuff. Um, so that yeah, I think I can do that. I just have to check. But the selected answers are posted, or they're posted online. And I think yes, I think that most of the bar companies do have answers for these, but I'm not 100% sure on that. I just have to check with Matsumoto and them about me posting my own stuff too. That's all. Um, logistically. Okay, so I was gonna talk. Okay, so property. So I don't have time to finish all of it, but what I can do if it helps, I don't have time to finish all of it tonight. So I can do a couple of things. One, I can annotate the notes like I did earlier for the MBEs, and I can do that for you guys. And then I can also post these sort of like checklists that I did. I can post those for the property essays, but I can also just record a property essay so that you guys can watch it because those probably just aren't fresh. They probably really just aren't fresh. And then if you want later on, just to make up for that, I can try to figure out like something else that I can do for you guys, workshop wise, if you guys need it later. But do you want to go over some property stuff tonight? I know we're in kind of torts land right now. What are you guys wanting? Okay. I'll record it then. I'll record it and that way it gets posted. Um, I should have some time to record it this weekend then. So, all right, cool. All right, well then I'm gonna end it. Okay, cool. That's good to know, Laura. Yeah, I'm trying to figure it out with the um with just doing it via live stream. It's different. But I think that that's a way that I can make it kind of visual for people. And then yeah, the checklist makes it so that it's more engaging, I think too. So good. I'm glad that you guys are liking those couple of those things. So I will keep doing it this way when we do the subject matter lectures. And thanks for bearing with me with this flu. Everybody get your flu shots because it's horrendous. Um, so yeah. All right, guys, have a good night and good luck. Thank you so much. Bye. Good night, Larry.